Negligence is the breach of a legal duty to act reasonably that is direct or proximate cause of injury to another. In non-legal language, negligence is carelessness that causes harm. Assume the hole in the rug had been there for 2 weeks. Failure to fix the hole is carelessness. The restaurant could be anticipate that someone would be injured by it. As a result, the restaurant will be liable for the customer's injury. The law requires that people and businesses act reasonably in attempting to prevent injuries. When someone acts unreasonably or carelessly, that person is negligent. A reasonable restaurant employee seeing hotel employee who had been alerted to hot water problems in the hotel would investigate and correct the problem. Failure to make them necessary repairs in these examples constitutes negligence. If the cause of a hotel guest injury was the carelessness of an employee, the hotel will be liable to the guest. Managers and employees of restaurants and hotels should strive to act reasonably in the way they perform their duties in order to avoid liability for negligence. Elements of a negligence case. A plaintiff suing in negligence must prove four elements. Failure to prove any one of them is fatal to plaintiff's case. The four elements are: first, the existence of a duty to act reasonably owed by the defendant to the plaintiff. Second, a breach of that duty. Third, injury to plaintiff. Fourth, proximate cause. This last element means the breach of duty must be the direct cause of the injury and no intervening cause exists. Existence of a duty to act reasonably. We do not owe to everyone the duty reasonably. We owe the duty to those people who would forcibly be injured by our actions. A restaurant can foresee that if the leg of a chair is broken, a patron will sit on the chair and fall. Therefore, the restaurant owes a duty to its guests to repair the chair. If the restaurant or hotel cannot foresee a particular type of injury, it does not owe a duty to protect patrons against that injury even though someone is in fact injured. Injury. To win a lawsuit, a plaintiff must have suffered injury as a result of defendant's breach of duty. The injury might be bodily harm. The legal term for this is personal injury, such as broken arm or head injury. The injury could also be property damage such as a dented car or emotional or monetary loss. Summary of the elements of negligence. Remember, before a hotel or restaurant will be liable to a plaintiff for negligence, all four elements must present. First, the existence of duty. Second, breach of that duty. Third, proximate cause. And fourth, injury. If any element is missing, the hotel or restaurant is not liable. Legal status of plaintiff. The duty of care owed by a hotel or restaurant for the safety of its patrons depends in many states on the legal status of the person injured. He may be an invitee, a licensee, or a trespasser. The greatest degree of care is owed to an invitee, the next to a licensee, and the least amount to a trespasser. Duty owed to invitees. In hospitality, an invitee is someone who comes to an establishment for the purpose for which the business is open to public, or for a purpose directly or indirectly connected with that business. For a hotel, invitees include guests and visitors of guests. For a restaurant, diners are invitees. For a bar, patrons are invitees. For all three, employees are invitees, as is a delivery person delivering some item necessary for the business. The hotel or restaurant owes a duty to its invitees to reasonably inspect the premises for dangerous conditions and to exercise reasonable care to eliminate them. Duty owed to licensees. A licensee is someone who has been given permission by the owner or occupier of a facility to enter or remain on the property, but his presence does not further defendant's business. An example of license is a witness or front desk clerk who, on a day off, goes to the place of employment to pick up a paycheck at the time the employee is not furthering the employer's business interest but nonetheless is on the premises with the employer's consent. Similarly, a former employee who enters the premises for purposes of meeting with a current employee is a licensee. Duty owed trespasser. The least duty owed to a trespasser, a person who enters a place without permission of a owner or occupier. If an employee who has been fired and ordered not to return to the hotel nonetheless enters the premises, he is a trespasser. Someone who enters a restaurant after it is closed for the night without the owner's permission is a trespasser. A landowner or a possessor does not owe a duty to safeguard a trespasser from injury due to condition on the land. Minority position. Some states have abolished the distinction between licensee, invitees, and trespasser, and the duties owed to each. Instead, in those states, the occupier of land owes a duty of care to all three. However, the standard of reasonable care may vary with the circumstances of the visitor's entry on the premises. No special duty owed to others. What about people who do not qualify as invitee, licensee, or trespasser? In most cases, no duty is owed. In the following case, the innkeeper had no relationship with the injured party and therefore owed no duty of care. And lastly, no duty owed on property not owned or maintained by the hospitality facility. A hotel or restaurant is generally not liable for injuries that occur to patron on property not owned by or maintained by it. Even if the property is near the hotel or restaurant's facility, thus a restaurant was not liable to diners who were assaulted in the parking lot located behind the restaurant but not owned or maintained by it. The court specifically noted that the restaurant did not pave, snowplow, clear, or patrol the area where the assault occurred.
So, good morning everyone. My topic for today is about negligence doctrines generally favoring defendants. Contributory negligence is the plaintiff's failure to exercise reasonable care for their safety. Contributory negligence can bar recovery or reduce the amount of compensation a plaintiff receives if their action increased the likelihood that an incident occurred. For example, is in a car accident between car A and car B, kay si car A kay kusog kay siya nagpadagan. Then si car B kay kubog siya nga nag-drive. So both drivers are engaged in negligent race creating behavior. So silang duham misalan if magbangga sila. Kay parehas man sila negligence. Then, comparative negligence. Comparative negligence, called non-absolute contributory negligence outside the United States, is a partial legal defense that reduces the amount of damages that a plaintiff can recover in a negligence-based claim based upon the degree to which the plaintiff's own negligence contributed to cause the injury. For example, ang guest sa hotel kay kabalo siya nga ang iyang sandal kay luag. So paslod niya sa hotel kay naay holded to, which is sa lapod sa hotel kay wala nila na fix ang katong hole. Then paslod sa guest sinatapilok siya tungod kay atong hole nga naa sa entrance sa hotel. So, naay 30% na responsible ang guest kay luag iyang sapatos. Then, 70% sa hotel kay katong hall is wala nila na fix. So, the plaintiff collects 70% from the defendant kay naa siya 30% na responsible for the damages. Then, the doctrines of last clear chance. The doctrine of last clear chance provides that where both parties are negligent, but the negligent act of one is appreciably later in point of time than of the other, or where it is impossible to determine whose fault or negligence brought about the occurrence of the incident, the one who had the last clear chance. So, for example, ani is na ay duha ka driver, si Becky o si Mike. So, Becky is driving in the opposite direction, then Mike is on the other side sa road. So, si Mike, medyo katulgon na siya, but he's still fighting to stay awake. Pero, iyang pag-drive medyo liko-liko na. So, si Becky, sa layo pa, nakita na niya nga adto ang dagan sa car ni Mike. But instead na mubalik siya sa iyang agi, nipadayon siya man siya pag-drive, so maotong nagbangga sila. So, naapauntay chance na mabalik si Becky sa iyang agi to avoid that incident. So, both Mike and Becky are negligent. Mike was driving while almost sleeping, and Becky failed to turn her car out of the way. Noted that Becky had a last clear chance to avoid the car accident, but she failed to do so. Then, assumption of rest. Assumption of the rest is a legal doctrine that may prevent an injured person from winning a personal injury lawsuit or getting an injury-related insurance settlement. The idea is that the plaintiff can't hold the defendant responsible if the plaintiff knowingly exposed him or herself to the possibility of an injury. So, a classic example of the assumption of rest doctrine is attending a baseball game or a basketball game. It is understood that when you go to a baseball game, there's a risk that a ball may be hit into the stand. So, assumption of rest is a third primarily negligence defense. A plaintiff is said to assure that the risk of injury if he voluntarily enters a dangerous situation, fully aware of the risk involved. So, voluntarily meant that the person assuming that the risk had a chance to avoid it. If the person had no choice to avoid the dangerous activity, then he cannot have assured the risk. That's all, and thank you.
Negligence doctrines generally favoring the plaintiff. Numerous legal doctrines are associated with negligence. In any negligence case, one or more of these doctrines may apply and affect the outcome. So, some favor the plaintiff by making the plaintiff's case easier to prove, and other benefits the defendant. So, we will examine first those that benefit the plaintiff and then those that favor the defendant. Res ipsa loquitur. So, in many negligence cases, the plaintiff has difficulty proving the necessary elements. So, evidence to prove defendant negligent does not always exist, though the facts of the cause may strongly suggest defendant was negligent. These legal doctrines of res ipsa loquitur aids the plaintiff in such a case. It applies in cases where the circumstances suggest the defendant was negligent, but no proof of specific acts of negligence exists. The doctrine of res ipsa loquitur, which means the thing speaks for itself, frees the plaintiff from the burden of proving the specific breach of duty committed by the defendant. In such a case, the doctrine of res ipsa loquitur creates an inference that defendant was negligent and allows the plaintiff to proceed with the lawsuit
without having to prove through witnesses or otherwise the specific way in which the defendant was negligent. So, to use this doctrine, plaintiff must prove the following three elements. First is the plaintiff's injury was caused by an accident that would not normally have happened without negligence. Second, the thing causing the injury was within the exclusive control of the defendant. Third, plaintiff did not provoke the accident. So, for example, if plaintiff had been throwing rocks up to the window from which the flour fell, and the rocks had dislodged the barrel of flour, causing it to fall. So, plaintiff would not be able to use res ipsa loquitur. Children and the reasonable person test. So, children do not comprehend dangers obvious to more mature persons. So, instead, children act impulsively. Um, Not are children able to weigh cause and effect accurately. This impacts the duty imposed by law on young people as well as the duty owed by adults to children. So, this law excuses a young child from negligent acts, and a person injured by a young child act is not entitled to compensation. So the duty owed by adults to act reasonably is usually greater when young children are involved. So unlike the adult, children cannot be expected to recognize risk and take appropriate precautions. Reasonable accommodations for children. So, a hotel must anticipate dangers and use reasonable care to protect against them when furnishing a room that will be occupied by children. Attractive nuisance doctrine. This doctrine is an outgrowth of youngsters' limited capability to detect danger and protect themselves from risk. So, an attractive nuisance is a potentially dangerous object or condition of exceptional interest to young people, so such as swimming pools, a large empty box, or a snow pile suitable for sliding accumulated by a plow. So, if an attractive nuisance exists on the property, the owner or occupier is required to exercise reasonable care to protect a child from associated risk. So, there are three elements of an attractive nuisance. First is a condition exists that is attractive to children and is like to cause them injury. Second, the owner or occupier of the land knows or should know of the condition. Third, due to the child's immaturity, he does not appreciate the danger. So, in these cases, the owner or occupier must take reasonable steps to eliminate the danger. Negligence per se doctrine. Negligence per se describes an act that violates a law or ordinance designed to protect the safety of the public. This doctrine is of great help to the plaintiff because he or she does not have to prove that defendant failed to act as a reasonable person. Instead, the only facts the plaintiff needs to prove are the existence of the law or ordinance. So, defendant's violation of it, the extent of the injury, and the proximate cause between the violation and the injury. The reasoning supporting the negligence per se doctrine is that the proprietor of an establishment has a duty always to comply with legal mandates designed to protect patrons. This legal duty applies even when the owner is unaware of the existence of the safety law. Obligations beyond regulation. So suppose a hotel full complies with a statute but the requirements of the law are inadequate to protect the guests. The hotel has a duty to exercise reasonable care to protect guests from injury. If satisfying the law falls short of reasonable care, the hotel must do more than what the statute requires. And in if the following case the hotel's compliance with the law did not protect it from liability for gas injuries. Strict or absolute liability. Normally, defendants are not liable unless they do something wrong. If a patron trips and falls in a restaurant solely because he is intoxicated, the restaurant will not be liable for any injuries sustained in the fall, since the restaurant was not negligent and it did not breach any duty owed to customer. Um, that exception is sometimes called strict liability and sometimes absolute liability. Strict liability imposes liability from an ultra-hazardous activity upon those who engage in it, such as activities that might include keeping wild animals or using explosive. This doctrine imposes liability for resulting injuries, even if the defendant took every precaution and was not negligent. The principle supporting this rule is that the ultra hazardous activity could be outlawed because of the danger it creates. Strict products liability. So, in recent times, the doctrine of strict liability has been extended significantly to sellers of defective products. Um, this application of strict liability is called strict product liability, and it imposes liability on the seller of a defective product without regard to negligence. A product is defective for this purpose if it is designed or manufactured improperly or if it contains inadequate warnings of dangers it presents. So restaurants and hotels can both benefit and be hurt by strict products liability if they buy products that are defective and incur a loss as a result. And also restaurants and hotels can also be sued in strict products liability if they sell defective products such as rancid tuna salad in the dining room or an exploding hair dryer from the gift shop. If that product was defective when it was sold to the hospitality facility, the restaurant or hotel can sue the manufacturer when the hotel or restaurant is sued by a customer or guest. Respondent superior. Hotels and restaurants employ many people, so in general, I, a employer is liable for the act of its employees done in their jobs. So employers are liable to their customers, guests, and other invitees for the negligence of their employees. This liability of the employer for the act of its employees is called respondent superior, which means let the master answer. So this doctrine is founded on the theory that an employee is an agent of the employer. So whenever an employee is performing the duties of the job, he or she is acting on behalf of the employer. So in other words, it encourages employers to exercise caution in the selection of employees and encourage employers to train their employees well. So this should have the desirable effect of limiting the numerous employees. Duty to invitees in danger. So the law in some states requires hotel and restaurant to lend a hand under certain circumstances. So this includes situations where the injury was caused by something under the defendant's control and lack of care would aggravate the injury. Non-deligible duties. So the duty imposed on a hospitality facility to keep the premises reasonably safe for guests is non-deligible. So the rule is intended to motivate the hotel or restaurant to monitor carefully the work of the independent contractors it hires.